So please just drop a comment. Let us know where you're joining us from, your name, and where you're joining us from. My name is Simi Where I'm the host of the Neutrals Nook. We're just going to give like a minute for more people to join before we start. Please, can you all hear me clearly? Kindly confirm that my audio is good.
Yes, we can hear you. Thank you.
Yes, we can hear you.
Thank you, Tutu, for joining. Thank you, Florence Shako from Kenya. Thank you, Tolu from California, and Aditu from Akure. So I'm going to just run through my slides. We do not want to take much of your time today. Welcome to the Neutrals Nook. This is our first episode, a first of more to come. I would like to especially welcome our distinguished judges joining us from various jurisdictions, our esteemed speakers, and all participants who have taken their time out to be here today. The Neutrals Nook is a dedicated platform created for the global ADR community. Our mission is just to raise awareness and understanding of ADR methods, share expert insights and real-world experiences, support continuous professional development, foster collaboration across jurisdictions, promote diversity and access to ADR. And our theme, our very first theme is, like we all know, court-mandated mediation, lessons from the USA, Nigeria, and Kenya. As courts across the globe contend with mounting caseloads, many have adopted mediation, not just as a case management tool, but as a more humane and efficient route to justice. Unlike traditional voluntary ADR processes, court-mandated mediation requires disputing parties in certain cases to engage in mediation, with the hope that the issues can be resolved amicably in mediation, reducing the burden on the courts and also promoting collaborative solutions. In today's session, we'll explore how 3 jurisdictions, the United States, Nigeria, and Kenya, have approached the development and implementation of court-mandated mediation or court-annexed mediation. Through this comparative lens, we aim to uncover practical lessons, highlight successes, and confront challenges these systems are faced. Like what Lee J mentioned in one of his posts, we're going to explore the good, the bad, and the ugly. We're hoping that we would have better systems across these jurisdictions as we share our experiences today. And that's the session objective. But before we go ahead, before I introduce our first speaker, we have 2 sets of poll questions. We're going to be launching one set now for our participants. So please answer those questions before we proceed to introduce our first speaker. Please, can you launch the poll, please? Thank you. For those who are co-hosts, you might not be able to answer these poll questions. It's just for the participants. Thank you. Okay. We're going to be ending the poll in 30 seconds so that we can proceed. We're also going to be dropping our social media, the links to our social media platforms in the comment section for people to please follow us. We have the full profiles of all our speakers on the LinkedIn page. I'm just going to be reading their abbreviated versions today. So we are sharing the results of the poll questions. So we have 96% answering that they have a court-mandated mediation program in their jurisdiction, and the issues being faced, 70% low public awareness and trust in mediation. We have 50% answer resistance from legal practitioners and judges, and lack of trained and experienced mediators. And these are the problems we're trying to fix, and that's why we are here today. So without further ado, I'll be introducing our first speaker, Lee J. Berman. I'll just read a brief summary of his profile. Lee J. Berman is a full-time commercial mediator based in the United States with over 30 years of experience and more than 2,700 cases successfully mediated, many of them high-profile and complex. He's been ranked as one of the top mediators in the US by Chambers USA and has held a Band 1 ranking since 2023. His accolades are numerous, including Counsel of the Year for Excellence in ADR 2024, Top Neutral by California's Daily Journal, Distinguished Neutral of the Year by the National Academy of Distinguished Neutrals, Peacemaker of the Year 2021. He is the founder of the American Institute of Mediation, a respected trainer of judges and mediators around the world, and a charter diplomat of ANADN. His contributions have spanned countries including Mexico, India, Jordan, and across the US, helping to shape court-connected mediation systems globally. Beyond accolades, what sets Mr. Berman apart is his commitment to building capacity in dispute resolution and mentoring the next generation of neutrals. You can read his full profile on our LinkedIn page. The link will be in our comment section. Ladies and gentlemen, please join me in giving a warm welcome to Mr. Lee J. Berman.
Simi, thank you so very much. That was so very kind. And after reading all of those organizations and recognitions, I thank you for having me. That's all the time we have.
Thank you.
I'm looking very forward to having this discussion. I've directed the launch of a court ADR program in Santa Barbara and have worked with judges and written ADR laws and things in India and Uzbekistan and Croatia and Jordan and of course across the US. So tell me how you'd like to begin this morning. Shall I launch right in, or did you have some questions for me?
Just launch right in. We'll ask the questions after all the speakers have spoken so that we can do it all at once. Thank you.
Wonderful. Thank you. So what I have found when I took the position as the director of the Court Annex Dispute Resolution Program in Santa Barbara County, California, we had the luxury of following some of the other counties in our state who had come before us in building those programs. So I had the opportunity to review their programs and to speak with each of the directors of those programs to ask them questions like, if you could build it again today from scratch, what would you do differently? Or what do you find is the best thing about the program, and what do you find to be the most challenging, and what helps people get to resolution in the way the program is designed, and what perhaps hinders that? So we learned a lot from them, and it was very interesting because we did a somewhat informal study and also looked at their resolution rate, recognizing that resolution rate alone isn't the only measure of success, but is a fairly respectable way to look at how a court annexed program is working. We built several things differently, but first, I would love to speak to what we found as the most important variables in building a court system that connected those court systems to success, again, as we defined it as high resolution rates. So the county directly beneath us built a program where they ordered people into mediation. Further, they set the date of the mediation as if it was a court appearance, so the parties didn't necessarily have input into the timing of the mediation. The judge just set the date. Third, they assigned a neutral from their pool of neutrals, a mediator from their pool of mediators. And fourth, the mediators were paid a very small stipend for the day, basically almost volunteering to do these mediations, because the amount of money was maybe what you would pay for dinner for 4 people or 2 or 3 people. So it was a relatively small stipend for the day. The mediators understood they were basically volunteering, and the parties were mandated every step of the way. They were mandated into the program, they were mandated with who their mediator was going to be, and they were mandated on the timing. That program had a resolution rate of 19% success. So basically 1 in 5 cases that went to their program ended in resolution, and 4 out of 5 of them rebounded back to the litigation process using court resources and having to go through that process. There was another county, Los Angeles County, the largest county, and this is where my home mediation practice is. Los Angeles is a very big city and county. To give you an idea, our bar association has 40,000 members in our county bar association in Los Angeles County. We had a mediation program in Los Angeles that ran for 17 years. The requirements for the mediators to get onto that panel were very, very low. They only had to have a 25-hour mediation training course, and that was it. There was no other requirement for admittance onto the panel other than, we used to joke, staying awake for 25 hours in a relatively basic mediation training course. So we had almost 2,200 mediators on that program. And at its peak, that program mediated 35,000 civil cases a year. So the sheer numbers were overwhelming. The qualification levels of the mediators was not necessarily that high. The parties were ordered into the program by the judges, so they didn't have a say in whether they mediated or not. And the judges gave them, rather than assigning a specific date, the judges gave them a completion date by when they had to have finished their mediation. And that was usually about 120 days from that order, which was their first appearance in the case. So usually that first appearance is about 60 days after the case is filed, so that they could serve the opposition and have a chance to answer and all of that. Then they would show up and the judge would say, all right, in the next 4 months, I want you all to have a mediation. And in that case, The judge didn't assign the mediator specifically, but the lawyers went to the office of mediators and they were given a list of mailing labels that had the mediator's name and address. And having been on that panel, I would ask lawyers, how did you end up picking me for this case? And some of them would say, well, he lives here, she lives here, so we just picked you because you were mutually inconvenient. And that's how they picked their mediators. So it wasn't a program that was very well designed. It was more just to get volumes of cases into a mediation program of any kind. And at the time we did the study, 32% of the cases that went into mediation in Los Angeles County ended in resolution. So 1/3 of the cases resolved and 2/3 went back to litigation, and again, using court resources and all of that. There was one more county we studied closely. Well, there were two. One was in the county directly to the north of us. There they had a judge who was very enthusiastic about mediation, had not taken a mediation training course, but was excited about the concept. And what he did is he created a very small, it was a small county, but he created a very small cadre of 8 or 10 or 12 mediators that he knew personally, and he kind of kept them in his pocket. And he would order from the bench that they go to this mediation program, and he would assign one of these mediators he knew to be their mediator. And he kept a very close eye on the mediation. The mediators had to report back to him. Did everybody show up at the mediation? Did everybody participate well? Was there good faith on both sides? And finally, what if the case did not resolve? What were the last numbers on the table? What was the defense's last offer and the plaintiff's last demand? So the judge kind of poked his nose very deeply into the mediation, taking a tremendous interest in it. But also that was contrary to our laws in California, where mediation is confidential and people can speak freely and not ever have that be spoken of again outside of the mediation process. So I was getting phone calls from lawyers in that jurisdiction saying, could you talk to our judge and let him know he can't ask these questions because our state laws make it confidential and he's not supposed to be able to ask. That program had about a 50% resolution rate. And in speaking with some of the judges in that county, they said, hey, we think it's great. We send all of our cases out to that program and only half of them come back. That's fantastic. So the county that I was working in is called Santa Barbara County, and it was sandwiched in the middle of all the other counties that we're speaking of. We built a program where we didn't order cases, parties, lawyers into mediation. We only ordered them to have a 10-minute consultation with me as the court's ADR director so that I could consult with them about what kind of case they had and about the different processes we offered, mediation, arbitration, special masters, all sorts of different alternative dispute resolution processes. 95% of them selected mediation because it was voluntary and not binding. And then we built a panel that had higher requirements than most of the other courts. So not only did they have to have a 40-hour mediation training course, but they had to have completed a certain number of mediations in order to apply for the panel. And they had to bring letters of recommendation from 3 lawyers they mediated for, vouching for their quality as a mediator, their ability, their skill. So we had a panel that we thought was highly qualified. We attracted neutrals from all over the state. And we had 2 different programs. One was for smaller cases, which in our jurisdiction was $50,000 and less. So most of your personal injury cases and smaller employment cases at the time and things like that would go into that program, where the mediators volunteered and they were not compensated. And yet the parties got to select their mediator. Oh no, I'm sorry, I fibbed. I selected the mediator by matching the skills and the experience of the mediator in certain areas of law to the kind of case that the parties had. and the parties got to set the timing, though there was also a completion date by when they had to be done. That program had a 62% resolution rate. So almost 2/3 of all the people who came into that program resolved their case, and only 1/3 of them went back to litigation. Then we had the program for over $50,000 for the larger general civil cases. And again, this didn't include family law, it was just what we call general civil. And in those cases, the mediators were paid their full market rate. And the lawyers, in selecting their mediators, had a website they could go to, and we also had a notebook with all the resumes of all the mediators printed out. So they could look at all of the different qualifications of all the mediators. They could look at what those mediators charged, and we had people all over the scale of what they charged. And some lawyers, in some cases, would say, it's not a very big case, it's not very complicated, let's hire a mediator who's more affordable. In other cases, they would say, this is a very difficult case. There's a lot at stake. It's complex in its facts. Maybe there are a lot of parties in it. Let's pay top dollar and get a really good mediator to help us settle this for sure the first time. And they would pay pretty significant fees to that mediator, but they got to choose. And what's also important is they had to agree on the mediator. So rather than the court as an disinterested third party assigning a person, counsel got together and agreed on the mediator. And again, if it was a case that was worth 50,000 or more, or where the claims were 50,000 or more, then they were paying that neutral. So the hypothesis we had was that if they were invested in selecting and agreeing on a neutral, they were going to be more committed to the process. If they were having to pay that neutral, they were more invested in that process. If they could set their own timing and say, we should do this sooner rather than later, or no, we need 3 or 4 months of discovery to really get our arms around this complex case, don't make us mediate until we know that, because only then will we be prepared to make a good settlement decision and advise our clients well. So they got to pick the mediator, they had to pay the mediator, they got to choose their date, and they got to opt into this program. There was nobody ordered into this program. They went into it voluntarily, with only the only mandate being that they come have a 10-minute conference with me to explain the various programs that we had to offer and how to access them. That program had a 72% resolution rate. So you can see the vast difference from 19% to 72%. So after the first year, we looked at all the numbers and we said, what do we attribute the difference to? And it came down to the very things we're talking about, all centered around voluntariness versus mandating. And so if they volunteer to go into the program that's offered instead of being ordered in, I did like the idea of them being ordered to an informational meeting with, somebody at the court to explain the various procedures and the benefits and all of that. If they get to select their neutral, their mediator, and if they agree together and select one together, that's the first step toward agreement, right? They're agreeing on that. Then they're agreeing on a date. Then they're agreeing on a location. So the pattern of agreement has already started in what we would call the convening stage, trying to bring a mediation together. And then they agree on the timing. And then finally, the qualifications of the neutrals and raising that bar and requiring neutrals to have a little bit more experience and a little bit more training, so that we're not having, random folks who may not be very skilled mediators representing the court in those moments. So if they have the ability to control their own destiny in all of these ways, they have a much higher probability of resolution. Where if the court orders and assigns the date, the mediator, etc., then there's a much lower probability of resolution. And in those programs, the attorneys report that the mediation actually delayed the case rather than shortening it. and that it added time and expense to prepare for a mediation that ultimately wasn't successful and was a distraction to them getting the case resolved rather than a help. And so as we think about designing programs, those are the variables that we decided from our little study were the most important to pay attention to: the voluntariness, the self-selection, the self-determination, all of the very core values of mediation that we all espouse to all the time. So that's the first download of information that I would give you about what we've learned. And I wouldn't say that's across the United States. It's a very small sampling out of California. But I do believe that that's what's consistent across the United States when it comes to programs that are more successful than others in mediation programs in a court system.
Thank you very much for that concise, in-depth presentation. Thank you so much for the data to back up everything that you have said today. And one thing that stands out to me is, the voluntariness, how it's improved the settlement rate from 19%, where the court had to, decide on who the mediator is, the time, schedule the time for the mediation, to when the parties get to appoint their mediator themselves, pay that, invest in the mediation. From a 90% settlement rate, it went to over 72% settlement rate. That's a very good one. Thank you so much. We're going to go into Q&A later on. Please, if you have questions, you can drop them in the comment section. We'll be taking notes of them. And we'll be moving on to our next speaker for today. Please, Mr. Lee J. Berman, please still hold on. We're going to go to Q&A very soon after all the speakers are done with their sessions. Thank you. So we have Honorable Justice Caroline Kendago joining us from Kenya. I'm going to be reading her profile. Thank you very much, my lord. Justice Honorable Caroline Kendago is a recently appointed judge of the High Court of Kenya. Prior to her elevation, she played a pivotal role as acting registrar, overseeing court-annexed mediation, ensuring the effective use of mediation within Kenya's judiciary. Admitted to the bar in 2006, Justice Kendago joined the judiciary in 2010 and has risen through the ranks to become a senior principal magistrate before her current appointment. She is an alumna of MOI University and the Kenya School of Law, and is currently pursuing a Master's of Law at the University of Nairobi. She has undertaken prestigious leadership programs, including the AIG Public Leaders Program at Oxford University. Her excellence has been widely recognized. She was named Judicial Officer of the Year 2021 by the Law Society of Kenya and received the Order of Grand Warrior OTW for her national service. Justice Kendago is deeply committed to mentorship and community service and brings a wealth of practical and policy insights into court-connected mediation systems. Please join me in welcoming Honorable Justice Caroline Kendago. You can read her full profile on our LinkedIn page. You're welcome, my lord.
Thank you very much. I'm very excited to join the call and learn from everyone. Berman, it was really nice hearing from you and just having the feel that we actually experience the same kind of challenges across the globe. And of course, beyond looking at the challenges is the bigger vision and just the dream that ADR works, mediation works, and what is it that we are all doing across the globe to pull these together and ensure that we just don't give it success in terms of the numbers, but also give a reflection in terms of what is really the experience that our clients are having out of mediation. To on to what Berman said, allow me to just give a reflection of what we looked at in back here in Kenya. on the conversation that then informed the implementation of court annexed mediation as part of the programs that we have within the judiciary. And one of the big major questions that we asked ourselves that is reflected in the blueprints that we have had post the constitution that we had in 2010 was just a reflection of, are we doing things the same way and expecting different results? So falling in back then to the challenges that we were experiencing, which included the huge backlog that we were having, the high case turnaround time, the experience that our clients were having, are some of the things that informed the implementation of mediation. In Kenya, mediation or the use of ADR mechanisms is a constitutional imperative. So it is very well spelled out that one of the roles of the judiciary is to promote the use of ADR mechanisms, of course, with a cap that comes in with ensuring that there are no ADR then does not become a stumbling block to access to justice or to infringement of rights. But the Constitution has given an imperative that binds the judiciary, that binds the quasi-judicial institutions that we have to promote the use of ADR mechanisms, and they're now coming into mediation. So with the reflection of the challenges that we are having, the real push was just to see that we can have mediation then come in as a mechanism that will assist us to overcome these challenges that we were having. And then forefront, when we started as a pilot phase. Of course, angling in with the fear, you're not sure how to start, you don't know where to get these mediators, you don't know how to inculcate the use of mediation within the case management process that we already had and was moving. You don't know how to bring on board the judges, the judicial officers, the judiciary team in terms of their role in this. And so when we started with the pilot phase, it was more of a random rollout. So we just went to the courts that we thought were ready to receive mediation. But falling back now after the pilot phase, we realized that we needed to have a better approach in terms of how we were bringing the courts on board. One was informed by the issue of the cost implication that was coming in, because now we had mediators who were coming on board. We had programs that were coming in addition to what we would do in every other day within the courts. And so we fell back to a scientific, more of a sieving mechanism that then informed the courts that we started off. During the pilot, we started with the family and commercial courts, and I think just because of the kind of courts, the kind of cases that are in those courts, and aiming that would then be able to resolve the family disputes faster, and then the commercial cases because of the amounts of money that are held in litigation. Then when we started now the rollout, we started looking at courts that had the huge backlogs. We started giving priority in terms of the launch to courts that had high case turnaround time. And then we also would look at the courts where our customer surveys were low. And coming back now on the reflection since the pilot to now, it was a very good idea to approach mediation from that first rollout, because we realized that what was working in Nairobi during the pilot phase was not necessarily what was working in other courts across the country. We realized that the kind of cases that perhaps would be very successful in the use of mediation in Nairobi may not be the kind of cases that would be successful in other regions. So because of that, then we came back and reviewed the practices that we were having. We invited Ms. Achere, who came to Kenya and did an evaluation. So one of the issues that I think that would really come is, even as you start off the implementation of court annexed mediation, there comes a moment where you pause and then have the reflections. And just like Berman said, you fall back to look at the things now that are working to improve them, and then the things that are making buying difficult or is preventing the success, then how is it then that you change from there? So after the external evaluation that we had with Mr. Chere, and of course together with other ADR interest groups in Kenya, we changed so many of the procedures that we were having. We changed the appointment of mediator, which we used to nominate, and then we tell them now, give us an order of priority. And the 60-day period that we have for mediation would be concluded even before the parties agree on who the mediator is. We fell back to change on how we were screening and looking at the cases. When we started off, we had such a very tight, like you look at the cases more of, they don't qualify to mediation, then you are looking for those few that are coming to mediation. But with the learning curve now, we fell back to look at cases that all cases qualify to go to mediation. Then we would look now at the few ones that perhaps would be having issues that may not. So we reduced our screening criteria from a list that we had of about 40 to now a screening criteria of only 3. One of the screening criteria that we even put with time, we have overcome it in that we were not sending cases that were of public interest to mediation. But over time, now we have some of the public interest litigation cases that have gone to mediation that were filed under the judicial review that have undergone mediation, and we haven't seen the kind of worry that we had initially, that it had a potential of coming up with a settlement that would not be in the public interest. The other criteria, if I can just mention, is about the issue of cases that involve children where there are issues of child abuse, domestic violence. And then, of course, we also put in a criteria there that just said if parties had already selected another ADR mechanism, then we give them the opportunity to go through that ADR mechanism instead of sending it to mediation. The model that we were adopted from the pilot and running through to the phase where we are now is mandated. We, I think, tried to look for a nice word just to move away from telling people that it is mandated. So we picked a nice word and said annexed. So that we would be able to get a buy-in with our parties, have them just look at it that we are just, it is mediation, but it is under the umbrella of the court. Some of the fears that we had that started off is parties would look at it that they are being sent away from the court process. I have filed my case in court. Why am I being sent to another process? I have filed my case so I can appear before a judge. Who is this third party that is now coming in to hear the matter? So court annexed mediation, but still it adopts the mandatory model. We looked at various countries across the country across the globe at that time, just to look at what is the kind of model that we want to adopt. We adopted a model that the mediators are not judges, they are not judicial officers, they are third parties that are accredited by an institution that we have, and they are paid more of a honorarium, almost close to what Berman said in terms of the amount that we pay. But because we were starting off under, and it was a whole new concept, it was difficult to now tell parties that we are, you'd meet the cost of the mediators. So we continue to shoulder the same, but a little later I'll just talk about what we are looking at in terms of sustainability and how we plan to slowly move away from that and now hand the baton back to parties and of course the mediators. Then the other issue about the model that we adopted is that we really struggled a bit in terms of whether to anchor this model under. Do we come up with some legislation then that will make a provision in terms of how we are going to go about it? And when we started off, we had pilot rules. We still don't have any act in Kenya that more of like for mediation. Apart from the Arbitration Act, actually, we don't have any other legislation for ADR. but we fell back to our bread and butter in the constitution and the imperative that is there. So we developed pilot rules, which we changed over time after the pilot phase, and then we had practice directions. And now when the conversation in the country, borrowing from now the interest that had been generated, we'd like to look at it that way, that the interest was generated on matters ADR, from what was happening in mediation and generally the implementation. So the model is currently now anchored under mediation rules, but we've had conversations both at the Senate, at the National Assembly, and we currently have a bill that is presented by other parties that is seeking to now give an umbrella on matters ADR. And of course, we also have a policy that an ADR policy that was developed very closely with the participation of the judiciary. The other bit about the model is, I think I mentioned about the mediators, that they are external, they are accredited. There's an accreditation committee that developed a code of ethics for them. They regulate their annual subscription. They have to renew their subscription every year. They also have to, they have to abide by the code of ethics. And if there's an issue, then the disciplinary proceedings are also handled by this same accreditation committee. Besides that, in terms of the institutional support, we have a task force, which is more of like a standing committee that looks at what is it that we are doing in mediation, what is the vision that we want to go, what is the legal and policy framework. So it's more of the think tank that assists with the implementation, and it is under the judiciary, but we have expanded the membership to include other stakeholders. So we have the lawyers on board, we have ADR interest groups on board, we have the Attorney General represented there. So making it have an external outlook as well, so that even as we're looking at a vision internally as an institution and we're talking about court-mandated mediation, we ensure that we have the external stakeholders on board with us and we are thinking together on what is it that we want to do in order to improve the uptake and implementation of mediation. Then we also have a secretariat that is chaired by a registrar. I've seen she's here with us. And that secretariat now provides a day-to-day management of mediation, coordinates the courts, because we realize that if we left the coordination of the implementation of mediation with the existing management that we have, then sometimes you lose out in terms of just the coordination, the adding value to the day-to-day management of it. Being able to very quickly pick up and say, there's an issue here, we need to do this differently. Being a point of reference where now the registrars that are supporting mediation across the country can come to for leadership, and then the same point now that becomes a gathering point for any feedback that is then escalated to the task force, which is the bigger umbrella. In terms of the process, I think more of what I think has been shared, the screening, we look at the cases, we notify the parties about the referral. When we started off with we do the nomination of mediators, but now we moved away and we are appointing the mediators from the register that is kept by the judiciary. The mediators are accredited according to different fields, so they are appointed according to those fields. We are currently looking at the use of technology and moving towards an automatic allocation of mediators from the register because of the numbers that we have. I think more like that about the issue of the process. One thing that we also picked up similar to what Berman was sharing was when we started off, we used to just send notices to parties and tell them that your matter has been referred to mediation. So there would be an uproar, people would give feedback and say, I was contacted by a stranger, somebody is a broker somewhere, somebody has reached out that I don't even know and told me it's a mediator, you know, those kind of questions. And then we also realized that our non-compliance rate shot up very high. So we reviewed that, and now even if we retain the control in terms of the mandatory, that once the court says it is referred to mediation, you submit, we now invite them before we send the cases. So we have the conversations with them. We tell them what the process is about. We tell them how the mediator will be paid, what is just the general information about what to even expect as they go to mediation. And we realized that it added a lot of value instead of them just receiving notices that the matter has been referred to mediation. And then it also helped us in terms of reflection of the screening criteria. So some of the gaps that we had in terms of the kind of cases we would send, now the quality was better, because with the interaction with the parties, they would give you some information that perhaps you couldn't pick from the reading of the file, that then sort of like informs you on what is even the approach to take with this matter once it is referred to mediation. And sometimes we've had some that during those conversations, we actually think that they are better off just to proceed through the other process. As a learning curve, starting off, one of the things that we really added value to the program is there was the challenge about culture change and introducing something new. In our country, we say that the biggest threat we make to each other is that I'll take you to court. So turning that around, we really needed to have the champions on board. So we reached out to stakeholders, ADR interest groups, women in ADR who we've seen our patron is here, Justice Alwatch, conversations that now gave a change. So you're not the only one talking about mediation. You are not the only ones preaching the gospel. We brought in other stakeholders, collaborations that have assisted us, and so moving in with the champions. And then when you look at the stakeholder engagements, when we started off, we thought that the conversion was more of the external stakeholders. But falling back as a learning curve, we realized that when you talk about stakeholder engagement, about sensitization, about training, it must also be an internal reflection, that you're also looking at the judiciary itself, the judges, the magistrates, the management, that they would get a buy-in, including even for us, we brought on board the Judicial Service Commission for them to just understand what is it that we are doing, what is the vision, can we have, what can we do in terms of the model that we are currently having that we can improve together. Then of course, the use of ICT. When we started off, we would just do the physical sessions, which mostly were in court, because people had this notion that when you do mediation outside, you almost feel like you are not within the court walls or the confines of the court. But because of the physical infrastructure that we're having, we expanded. We started explaining to them that it is okay to have these mediations outside and bring us the settlement agreements. But of course, again, the introduction of online mediation was a game changer after COVID. And then now we have mediations that are proceeding without necessarily having that challenge of a party saying that they're not able to participate because they're not within either the physical jurisdiction or vicinities to attend. Then the issue of the development of materials and just across that are tailor-made for each party, because we realize that when you do a general training, sometimes you miss out on what are the interests for a particular group. So we started developing our training materials that are tailor-made for particular groups. So we have for the judges and the judicial officers, we have IC materials for mediators, we have IC materials that are prepared now even for the parties and the advocates. I think I'd like to stop there. The other bit is that in the implementation and as a learning curve, we moved away from looking at mediation as a pilot, from looking at it as just a mechanism that we were trying, to now a formal implementation within the judiciary across the country. And one of the major achievements that we have had is that it is now included as part of our performance measurement and management, and has been given an indicator. So we no longer look at it like it is just any other, but given the same measurement and the same query as you'd ask a court about the number of cases that they have had and determined is now a fallback to even look at in the performance measurement on how they are promoting the use of ADR and in this context, mediation. And my parting shot is that with their challenges, but mediation works. Thank you, and back to you.
Thank you so much, my lord. That was a very insightful session. Thank you. And I would like to highlight some of the things you mentioned that stood out for me. I like the fact that there was, at every point in time, you were reviewing the process and improving on it to make sure that what you have works for your jurisdiction. And also you mentioned something that really stood out is that what works in Nairobi might not work somewhere else. And that was noted. And the accreditation committee, ensuring that you have mediators that are up to par with what is needed in your jurisdiction. Thank you very much once again, my lord. I would be moving on to Mrs. Achere Koo, my boss, my esteemed boss, the LMDC CEO and director. I'll be reading our profile. The full profiles are available on our LinkedIn page. This is just a summarized version of it. Mrs. Achere Koo is the CEO and director of the Lagos Multi-Door Courthouse, the first court-connected ADR center in Africa, with over 22 years of experience in alternative dispute resolution. Mrs. Koo is a respected expert in mediation, arbitration, peace building, and policy development. She has extensive experience in case administration, restorative justice, ethics training, mediation curriculum design, and public policy reform. Her work spans national and regional impact, including consulting for the Judiciary of Kenya, the International Development Law Organization, and serving as an external evaluator for Kenya's Milimani Law Court. Mrs. Koo was instrumental in establishing the LMDC and has trained mediators across Kaduna, Abia, and other jurisdictions under international programs. Her passion for access to justice and community mediation services continues to shape how ADR is delivered in Nigeria and beyond. You're welcome, Mrs. Koo.
Thank you very much, Simi. It's a great honor to be in the midst of people like this, with Berman, with Kendagor, and the other facilitators speaking today. I'm going to share my slides so I don't miss out what I want to talk about. Simi, so I'll be sharing. I'm sharing the right thing right now. Simi, please confirm that everybody can see my slides.
Yes, we can, ma.
Okay, awesome. So now I'm just going to run through how we got to where we were, what we practice in terms of the legal backing. I think that's very important. Many people, many jurisdictions find out, and like I heard Kendagor say, sometimes you just give a go at it. You don't even have a law yet, and you base it on the Constitution. So it's good to see the progression that we've made across the years. And then we look at the Lagos Multi-Door Courthouse, kind of just see what we've done briefly. I'll speak to those slides. What had recent developments, and then let's look at recommendations and conclusion. I'll start this way. Yesterday, a classmate of mine who resides in the UK sent me a WhatsApp chat, and this is what I've posted here. She said, it concerns distribution of family estate. And I'm wondering why the suggestion to go to the multi-door courthouse, especially where it is clear that the distribution of estate is subject to the administration of estate laws. Although the claimant is trying to have the estate fall under customary laws, is it that the multi-door courthouse laws don't apply? And is it just whatever the parties bring to the MDC? This was a concern that she had. And then she also had another concern, that it's difficult for her or for her family to reach an agreement if the discussions are based on lies and forgeries. Now, this case is already in court, right? And this was my response to her. I have a bit of a lag. Anyway, I responded letting her know that the party's decision always prevails. The party's decision prevails. That's the essence of mediation. This does not mean the law does not apply. But the mediation process gives the parties an opportunity to consider the law and also discuss outside of the law. Many times when parties are mandated to go to mediation, they feel, I've come to the court. I've heard Caroline say that, I've come to the court and the court should handle my matter. Why are you sending me out of the court system? And this obviously is her own perception. Why should you send me out of the court system? The administration of estate laws should take place immediately. But then what mediation does differently, even when it is mandated by the court, is that it gives the parties an opportunity to discuss the law and the things that you have, the nuances that are outside of the law that the law cannot deal with. Now, I also said in terms of the forgery and lies that she alluded to, this issue should be raised in mediation, right? It is difficult to reach an agreement under circumstances where there's the belief that there are forgeries and lies. Definitely, it's tough to reach an agreement under those circumstances. However, mediation clarifies issues and parties may see things differently and take a decision either to settle or go back to court. And that's the beauty about mediation. And I dare say court-mandated mediation. Berman, I heard you say we moved from like a 19% and we got all the way up there in terms of voluntariness. And I think that would depend on the jurisdiction, right? Let's look at what Nigeria has experienced. So far, typically, I'm listening to Berman and listening to Kentgo. We started out pretty much same, largely adversarial system, prolonged legal battles, high cost of litigation, backlog of cases. And then came the Lagos Multi-Door Courthouse, which was established as the first court-connected ADR center in Africa. That was when it really started, where the change really started. And at that time was like, this is just too much. What can we do to change things and switch the narrative completely? And in fact, then we felt that we would just decongest the courts with mediation. And then how did it happen? There was a collaboration between the Lagos State Judiciary and the Negotiation and Conflict Management Group. So the way Lagos started out as a public-private partnership, of course, with support from donors and all of that. And then even if the Lagos Multi-Door Courthouse was established in 2002, this background is important, it was in 2007 that the LMDC law, Lagos Multi-Door Courthouse law, was established and provided statutory mandate to facilitate court-referred mediation. So the LMDC is now a full-fledged Lagos state institution, because people always ask, who do you belong to? The Multi-Door Courthouse in Lagos, and that's different across the country. For Lagos, it is fully fledged. It's a fully fledged state institution, however, connected to the Lagos State Judiciary, yet independent. Look at those nuances. I think it's quite unique that it's created that way. It's connected to the court, but yet independent, such that people can trust the process. I'm sure we're going to have questions on that. Right now, we have over 21 states in Nigeria that have a court-connected multi-door courthouse. In Nigeria, we have 36 states and the Federal Capital Territory. Let's look at the multi-level court perspective. At the National Judicial Council, it advocated for the use of ADR across the judiciary in Nigeria. And that's very important, that at that level, there was the push that ADR works. And then based on that push, many states began to, starting with Lagos, change and amend their civil procedure rules. And these civil procedure rules included mandatory referral to ADR. Not all of them, we're going to look at some of them. The National Industrial Court, which deals with industrial disputes, also provided for referral to ADR. Let's see to what extent it's mandatory. Then the Court of Appeal also provided for referral to ADR, then the Supreme Court Mediation Program. And of course, our Constitution makes provision for alternative dispute resolution, but particularly where it has to deal with foreign policy and under the fundamental objectives and directive principles of state policy. But it's good enough that the Constitution recognizes, in actual words, negotiation, conciliation, mediation, arbitration, and so on and so forth. So just to give you a sense of the history, is so much more, but gives you a sense of how we've got to where we are. Let's look at specifics in terms of what exactly is mandatory court referral in Nigeria. Let's look at the High Court of Lagos Civil Procedure Rules. Now, these rules have been used, the Lagos rules have been used across the nation. So that's why we just piggy off the Lagos state rules, and we can use that to juxtapose what has happened in other states, not completely, but to a great extent. Now, Order 2, Rule 1 says that the court shall further the overriding objectives by actively managing cases, and active case management includes, right? So the courts believe that active management of cases includes mandating the parties to use an ADR mechanism where the court considers it appropriate and facilitating the use of such procedure. This is very key. Now, the thinking is when you come to the court, what do you come to the court for? You come to the court for a resolution. Look at what my classmate said. Why are you sending me to the court when administration of estate process should just kick in? And I say, why not? I mean, why are you sending me to the multi-door courthouse? And I say, why not? Why not? What was your initial reason for coming to the court? You want the case resolved, ultimately. Now, what court-mandated mediation can do and does do is that it gives you an opportunity to discuss. And that's what it is, just like the earlier cases of Donut and Railtrack and the remaining cases that followed after. It's just saying you may not force the horse to drink the water, but you should get the horse to the water side at least. And that's what we tell counsel. Come to the table. Come and see if you want to resolve. Come and listen and just try that out. If it doesn't work, then you go back, but at least give it that opportunity. That's the mandatory referral that the Lagos court has adopted. In addition, Order 5 Rule 8 says that all originating processes filed in the registry will be screened to determine suitability for ADR and may be referred to the Lagos Multi-Door Courthouse and so on and so forth. Now, what this means is different. Apart from a mandatory referral to cases currently ongoing within the court's dockets, when you walk into the courthouse and you file a matter, all originating processes are screened to determine should it go on the ADR track or should it go to trial. What the court is doing is actively managing and saying to the parties who come that there's a faster way to resolve your disputes. Take that route, and we're going to help you along that route. That's what Order 5 Rule 8 is saying. Order 53 Rule 2 then says, where an offer of settlement is made to a party and the party rejects it. So you've gone through the whole hog of mediation. You're not comfortable with the offer. And this is very instructive for me. You then say, we must go to trial. And then you go to trial, and then they offered you 1 million naira, for instance. You go to trial. At the end of the day, the judgment is still 1 million naira. Let's look at it. And the said party eventually succeeds at trial, but the award is not in excess of the offer of settlement earlier made. It seems like you've wasted the time of the court, and which is why the court is very big on mandatory referral. So the rule says that the winning party shall pay the costs of the losing party from the time of the offer of settlement up to judgment. I think this is beautiful. What I'm not seeing, and maybe there's case law on it, is whether this has been taken into consideration and whether it's being used. But I think it's very, very useful. Let's go to National Industrial Court. So you see within the High Court rules for Lagos, and has been copied across some states in Nigeria, there is mandatory referral, not completely mandatory. In some circumstances, they will ask the parties, but the rules have made that provision. For the National Industrial Court, Order 42 of the National Industrial Court of Nigeria Civil Procedure Rule says, where the parties before the court have indicated their desire, then you see more of a voluntary approach. They have to indicate their desire for an amicable settlement of their dispute. The court may adjourn the matter to allow the parties negotiate. This is not mediation, so we probably need to look into that a bit and reach an amicable agreement. However, this was further clarified in the rules of the NICN EDR Center, where it says either of the parties in a dispute may, upon filing of his or her action before the court, apply to the president for the matter to be resolved. So either party can apply, or they indicate their desire. And then in the act itself, it empowers the promotion of reconciliation. So we see under the National Industrial Court relevant provisions in the rules and the center rules and the act, we can see a clear mandatory referral to mediation. Let's go to the Court of Appeal. Order 16 of the Court of Appeal rules says that at any time before an appeal is set down for hearing, the court may, now this is also discretionary, in appropriate circumstances, upon the request of any of the parties, refer the appeal to the Court of Appeal Mediation Program. Provided that such appeal is of a purely civil nature and so on and so forth, relates to liquidated money demand, matrimonial causes, and gives us, an idea of the kind of cases the Court of Appeal wants to see go to ADR. But we can see that the court here, even in Order 8 Rule 1 again, it's where any or both parties indicate an interest. The court is saying not necessarily mandatory. But when it gets to the rules, Order 8 Rule 2, it gives a proviso. The court may suo motu, that's mandatory, or upon the application of any or both of the parties, refer pending civil appeal. So those cases already within the court system, the court is saying, you know what, the court may, if it feels the circumstances are right, mandatorily refer. So we see a bit of mandatory referral for the Court of Appeal and the High Court rules. For the National Industrial Court, we're seeing less of that, probably because of the case types, and so on and so forth. You see that across the multi-door courthouse practice direction. The magistrate court law, rules itself provides for mandatory referral. They can issue an order. Section 80 is novel of the Arbitration and Mediation Act 2023. This is in terms of new innovations that have come in based on policy review, which now led to the enactment of this act. Previously in Nigeria, we had the Arbitration and Conciliation Act. We didn't have anything covering mediation. So this is novel for us. So in 2023, this particular section then says, where parties have agreed to mediate and have expressly undertaken not to initiate arbitral or judicial proceedings with respect to an existing or future dispute during a specified time until a specified time has occurred, such an undertaking shall be given effect by the arbitral tribunal or court. Now, let's talk about mediation in particular. So the courts now recognize, we didn't have this provision before, the courts recognize where the parties have agreed to mediate, and you come to the court, and the ADR clause or the dispute resolution clause shows that you had intention to mediate. The court will expect you to go to mediation first, which is some kind of mandatory referral, but based on the agreement of the parties. Now, for the Lagos multi-door courthouse, yes, it's the first. How do cases come in? They come in through walk-ins, court referrals, direct intervention. So you can walk in, you can get court referrals, which we talked about are mandatory, and then of course through direct intervention. Over 28,000 cases have been received were received as at 2024. What kind of methods do we use for dispute resolution, mediation, arbitration, mutual variation, so on and so forth? Number of cases resolved, over 7,000. Now, this is very instructive for me. I just imagine if these cases had not been resolved, we have over 55 billion in terms of in Naira claims that have been recovered, and over $56 million from 2017 to 2024. And for me, this is a backing for court-mandated mediation. Claims are different, Berman. Claims are different. In some claims, no matter how you allow the parties engage in voluntariness and all of that, they just won't come. Look at the numbers, even when it's mandated and in some circumstances voluntary. I'll discuss something else. Then for the panel of neutrals, we have over 300 mediators, arbitrators, and restorative justice facilitators. Now, what we do in terms of picking mediators is that we appoint. We don't suggest a list, we appoint, except the parties' requests. So that door is open. Parties can request, for who they want to be their mediator. That what we do is a bit of a painstaking process. We look at different factors before we appoint mediators. We look at expertise, we look at availability, we look now at expertise online and physical mediation. Online versus physical mediation. Some are very good with online mediation and some are better with physical mediation. You have to have those considerations. We look at age. Yes, in our culture, for some cases, if you have chiefs attending a mediation, you wouldn't bring a young person except the person is an expert and they know he's an expert in a certain area, but you just put in somebody, who is a bit older. We also look at tribe and religion and sex. Now, these are factors that you need to take into consideration. I once handled a case in which we were two women. At some point, handling a marital dispute. And at some point, the man said, no, balance this out. I want a man in the room with me. So, we learn over time that these are things that you must take into consideration in our climate. At least that's what we've seen. Things that are key to make sure that mediation works and that the court trusts us, even in the mandation, is to ensure that there's adequate training. And we went into that. And not just the multi-door, but there's ICMC. There's so many institutions that train in Nigeria. I heard Caroline talk about, particular institution training. No, in Nigeria, we don't have a particular institution. We have a multiplicity of institutions that train. What is important is that they provide the basic minimum standard. The Lagos Multi-Door goes beyond that and provides a mentorship on live mentorship, which I think is very important for us to adopt, that when you become a mediator, you just don't set out. You should be able to have some mentorship, even if it's not in a structured system or as structured, but something like that should happen because we see all kinds of practices on the field. Of course, we have other kinds of training. Then I must talk about online dispute resolution now. And that I heard Caroline talk about that too. During COVID, we shifted completely online, and then we've been doing that. In fact, many people don't want to come physically anymore. So I think it's a huge recommendation, and we're going to a point where we're saying from the court system itself, there should be a direct referral online. In fact, it's happening now, just that we're using WhatsApp. You just have to make do what you have. We're using WhatsApp, so you don't have to bring any cases to us physically. We just get the documents scanned onto a platform, we pick them up and we call the parties in, we resolve and go. And some parties never walk into the center. Everything is done completely online and signed either through email online or DocuSign, So online dispute resolution is another way that court-mandated mediation can work, or even not voluntary mediation, whatever it is, but ODR, I can tell you works. The challenge in our client is that we need a lot of training. You have people who attend mediation and don't seem to understand that it is a serious process. So you can have people who are in the kitchen, driving, in the market, and they're mediating. So that's just crazy. So those are things that we need to work on to make sure that they focus on the process. Now, the Lagos Settlement Week, I was listening to Berman. I agree in terms of voluntariness. Or maybe not. Let me talk about Lagos Settlement Week. Lagos Settlement Week is a short period, just a week within which courts mandate parties to go to. Both ways, both mandatory and voluntary. So it's a combination of factors. Right now, we're about to go into the process, and what we do is that we go around the courts and we screen the files. And then some lawyers walk in directly and say, look, this is vacation period. I want my cases to go to the multi-door courthouse voluntarily. While the court allows us to screen the files and set down the cases and issue an enrollment order, send those cases to the multi-door courthouse within that period of vacation. And we're saying the court is on vacation anyway. Why shouldn't your case come to mediation? And we found out that within the settlement week, we have a higher percent of settlement, over 50-something% settlement rate, when it is a short time frame, that I can say, short time frame within which to resolve and then maybe go back to court. So that's a learning curve I can say we have. We've included restorative justice, so it's not purely civil cases that we're handling now. We're handling minor criminal cases within those cases that can be condoned. So that's just to give an outline of, and then in Nigeria, like I said, this is the map of Nigeria. You can see across Nigeria, it's just going all colors. Over 21 states now have multi-door courthouses, which has really helped with court annex mediation, not necessarily mandated, both voluntary and mandated across the states in Nigeria. Now, what kind of cases do we handle? A multiplicity. Any civil, Caroline, I heard you talk about that. Many kind of cases come. In fact, I like the fact that I talked about public policy type cases or public interest cases. We have had a rethinking fundamental human rights cases. We used to screen those out, but now we're beginning to think that sometimes the belly of the fundamental human rights cases is not really what they've written on paper. It's way more than what they've written. So we're admitting a multiplicity of cases, and we've always done that. Matrimonial causes, telecommunications, is becoming a lot more specialized. Recently, we had a case in which a party was saying, I need an expert to determine if this IT work was complete. The mediator won't be able to do that. So we're having experts on panel, just to put that as a learning curve. We've had experts on panel, estate surveyors, land surveyors, IT experts, engineers. So we just have them on call so that when we need them, parties can make use of them. What are the benefits? I'm sure we all appreciate the benefits of court-mandated mediation, particularly enforceability, because at the end of the day, the terms of settlement become a court judgment. And that's very important for the parties that come to us. Not all parties. We recently had a case in which the parties say, look, I even want complete anonymity, complete confidentiality. I don't want to go to court. So yes, enforceability is good for those who need it when they need it, but there are those who really, really just need you to resolve their disputes and they don't need to go back to the court. And there are other benefits which I've listed out there. Recent developments, I've talked about the Arbitration and Mediation Act. Now we have the Judicial Advocacy. We have the National Policy on Arbitration and ADR 2024. This was important. It was the National ADR Committee that made sure we had the Arbitration and Mediation Act. Now we have the National Policy on Arbitration and ADR, which is looking into institutional oversight. You know, I've said that we have a multiplicity of institutions that are training. Now we're looking more into transparency and merit and accountability in decisions, and I'm sure it's going to spill over into training and so on and so forth. Of course, professional standards, capacity building, that's what this policy is looking at, policy enforcement, and so on and so forth. Recommendations, I think we need to train. I'm very big on training because we need to get it right. We need to ensure that the mediators know what they are doing so that people buy into the process, people trust the process, that the mediators know what they are doing, they're good at it. And then we need to work on ethics. Ethics are standard. Mediation ethics are standard. It should be across all clients. You know, so I say train, train, and train. Institutional strengthening in Nigeria. I know we have challenges with location. So we need to deal with that. I'm not sure how it is in other places. Then technological issues, I've talked about ODR, it works, but issues with data, acceptability, commitment, and all of that are there. Payment of mediators. Berman, Caroline, still in the same place in Nigeria. We're having a challenge with this, but we're currently dealing with it. We're turning away from it quite quickly to see how, as Berman said, mediators should be paid from the parties. Parties should pay and mediators should be paid from those fees. And that's very crucial because we can see that it's even affecting settlement rates. We've been on this for over 20 plus years now, and we're still paying a pittance. So that really needs to be worked on. Then, of course, a lot of sensitization. It amazes me, we've been sensitizing people since 2002. We're still sensitizing, but sensitization goes on because it's needed. And then digitization, very key. Caroline, you talked about it. We are working on that also, where the system can pick the mediator. I don't know how that will work, but we can feed in parent.
Can no longer hear Mrs. Cole. I think her network might have dropped out of the meeting.
What a shame. She was just getting to a really good part about how the system can help pick the right media. I was waiting to see if she was going to invoke AI. See me while you're doing that. What fascinating speakers and programs. I am having so much fun hearing about everything that they've developed in Kenya and Nigeria so far. Just wonderful.
Thank you very much. She will be joining us back shortly. Please, we are collecting the questions. If you have questions, please drop your questions. We'll be taking the questions after Phyllis and Adewale's session in 20 minutes. I'm sure Mrs. Cole is just about to rush round off our own session. Thank you. Please drop in your questions. Thank you. Should we go ahead with Phyllis Wangwe since Mrs. Cole was just about to round up? Phyllis, are you available to take over? I'll just read Phyllis' profile. Okay. Okay. Phyllis Wangwe is an advocate of the High Court of Kenya and a highly respected dispute resolution expert with Wangwe and Co. Associates. She's an experienced arbitrator, mediator, and conciliator, as well as a trainer of trainers in mediation, ESG, and financial literacy. Phyllis serves as a trustee of the Kenya National Chamber of Commerce and Industry and brings a wealth of experience from the banking sector, having worked with institutions such as Standard Chartered, MBK, and Kenya Bankers Association. She's actively involved in several professional bodies, including the Chartered Institute of Arbitrators, the Law Society of Kenya, and the East African Law Society. She's also the founder of Pence Global Services and the Center for Economic Empowerment and Development, where she champions community-based empowerment, entrepreneurship, and financial inclusion, especially among marginalized groups. You can read more about Phyllis on our profile on LinkedIn. You're welcome, Phyllis. I think Ms. Cole is back. Can you just give her 2 minutes to round off our session? Thank you. Mrs. Cole, please, you have the floor.
Thank you. I hope I wasn't out for too long. See me?
For like 3 minutes.
But you got to the point of lawyers' incentives?
No, we didn't. We stopped at digitalization.
Oh, great. So just one more point. Lawyers' incentives and the need to train lawyers on how to bill as mediation advocates. That's a huge challenge because they come to the table thinking that mediation is an alarming drop in revenue. You know, they don't see how it can help their practice. It's still a problem till now. So it's something we need to deal with and constantly train and take that quite seriously. Thank you so much. It was a great pleasure speaking. Thank you.
Thank you so much, Mrs. Cole, for that well-delivered and valuable session. Thank you very much. I would like to highlight that the LMDC, you know, she mentioned in her presentation that it has settled 7,000 cases, over 7,000 cases between 2017 to 2024. And there's also a mentorship program. That is one thing that stood out for the LMDC. You know, we had similar stories from all the other speakers. The mentorship program ensuring that we have mediators that are prepared, you know, to take up these cases. And one thing that has, you know, echoed from other speakers is payment of mediators. You know, the payments, the poor payment of mediators, and how Lijay has mentioned, you know, how that has been sorted out in his own jurisdiction, and I think that would help out with, you know, in Kenya and also in Nigeria, having parties bear the cost for these sessions. Thank you very much once again, Mrs. Cole. We'll be moving on to Phyllis. You're welcome. You have the floor, Phyllis. Thank you.
Thank you very much. I hope you can all hear me and hear me well. Yes. I'll tone it down a little because I know part of the audience, not all of them are mediators, not all of them are from the legal sector, just more like a story so that we can all be up to speed and all just enjoy the session. So for me, I'm going to share on my journey as a mediator. How did I get to be where I am at today? And thank you very much, Nux, for having me on air today. And very happy to be here with everyone. So basically, I started out as a banker. And as a banker, I decided to get into the legal space. So I went back to law school and went through everything. And on the 4th year, Professor Obile taught us on ADR. And I was shocked. I was like, you mean there's something like ADR, alternative dispute resolution? Sometimes we call it appropriate dispute resolution mechanisms. I was shocked and wondered why people had not embraced it more. And I was very excited about it, but you realize a few years ago, not many people took ADR very seriously. So back in the banking space, because I was studying as I was working, I did more of ADR classes, mediation, arbitration. And interestingly, because also the bank at that point did not appreciate it so much as I'd done my legal degree and I was entitled to days off to go and study, that one I actually had to take leave days off to go and study. And ideally, they should have paid for the courses because the banking structure was such that we were paid for some of these courses. But for some strange reason, they didn't want to pay for me because they didn't really understand this concept of ADR. So I continued and I did my mediation, I did my arbitration. And at some point, just within the banking sector, I landed in the debt collection department, remedial department. That is where we get the bad and doubtful debts. Those are the debts that are like literally written off and the bank does not really expect to get much from them. When I looked at the portfolios that I was given, I realized that quite a number of these cases were already in court. And when I talked to the staff of remedial and asked, why were these cases in court? They'd say they're already in court and there's nothing we can do. So you realize that at that point, many of the bankers had not done a law degree. Let's say 99% of the bankers had not done a law degree. 99.9% had not done a law degree. At the same time, the lawyers who had come employed in the bank, hardly any of them had a banking background. So based on that, I told them, no, the matter may have gone to court, but as long as the decree, the end of it has not come, we have an opportunity to pull it out of court and negotiate. And when I looked at some of those matters, unfortunately, sometimes I'd find like, because that time the Duplam rule was not applying, I found like sometimes 50% was interests. In fact, let's say 70 to 80% many times was interest and bank charges. From an integrity point of view and all that, I felt that was wrong. And when I talked to the staff, they were like, there's nothing we can do. This matter is already in court and it has to go that way. I said, no, we don't have to go that way. And I'm giving you this position authoritatively as a lawyer. And as long as the matter has not ended in court, we have an opportunity. The turnaround of that is that we got 90% of those cases out of court and 90% of them were actually paid. Because then I got to, in the process of mediating and negotiating, now using all the skills that I had, I would negotiate in between the bank and the client and maybe get a part of it written off totally. And then they'd have to pay a part of it with a payment plan, and they'd finish their debts and they'd be absolved from their debts, then they'd be free. And the bank would actually give them a certificate that they had cleared their loans. And that was great. And that is when I even got more and more interested in mediation, particularly with now the knowledge that I had. And at some point, again, I joined the credit information sharing. That was the time credit information sharing was getting into Kenya. And it's at that point that I also expressed to them that, look here, these debts that are out there don't always have to go to court. It's good we give the debtors an opportunity to negotiate and pay their debts, because we even had some exposure trips where we had gone to places like South Africa and we're looking at the court system, and it was so sad to learn that there are some cases whereby some people had even taken their lives, committed suicide because they could not pay their debts. So looking at that and having looked at various countries, because you look at Germany, Australia, you find that in the first world, when somebody is not working and there is credit, let's say you stop your work for a year or two, you simply report you've stopped working, and therefore interest stops applying, and they give you an opportunity to get a job, and then now you can now repay the debts. You find that is not there. That was not there in Kenya. It's not there in Africa. Whether you're still at the workplace or not, the banks expect you to pay. So having looked at that, I presented a paper to the banking sector that is domesticating ADR in Kenya. That's some time ago, about 2010. And it was absorbed, and it's actually what guides the banking sector. It's a fundamental principle, a pinnacle that the banking sector is using in approaching ADR. Because initially they didn't know about it, and they now picked it up, and it's now been structured, and you find that even now in the banking sector, they've embraced ADR more. You find that there is actually a center for dispute resolution, particularly when it comes to credit, and then also other sectors, other departments of the bank, not just necessarily credit, but other departments of the bank are encouraged to settle out of court as much as possible. So that was briefly how I got into the ADR space, my interest, and how I grew in it to the point where I am right now. And we may be asking, because I know there are some people here that are not lawyers. You don't have to be a lawyer to be a mediator. You don't have to have legal knowledge to be a mediator. Amongst mediators in Kenya right now, we have teachers who are mediators. We have psychologists who are mediators. We have religious people who are mediators. We have engineers. Actually, we have mediators from across all the sectors. And why is that so? The truth is, there is no place that there can be no dispute. As long as there are two people interacting, even within ourselves, we find that there are disputes that have to be addressed. But even sometimes, even amongst ourselves as mediators, we do find that sometimes we don't agree on one or two issues in some of the groups that I am in. And other mediators have to come in and assist the two mediators that are not agreeing to actually agree. So disputes are positive depending on how they are handled, and you don't have to be a mediator. You don't have to have legal background to do mediation. You just have to love peace. You have to be a peace builder. If you are interested in peace, then you can always be equipped to learn how to deal with disputes and help people resolve their disputes in different sectors, whether it is family issues, whether it is the workplace, whether it is in the marketplace. As long as you are keen on not seeing people fighting, as long as your joy, people are different, we could talk of nurses and that, but if your joy is not seeing people fighting, then you're a good candidate to be a mediator. And for me personally, what I'd say, my biggest joy as a mediator is when I help the parties resolve their disputes. And the toughest time for me is when I don't see why they're not solving. Because whether we like it or not, as mediators, when we come on, our job is to facilitate. So we help disputing parties reach a compromise, collaborate, and agree on the way forward. But even as we do it, the case is theirs, they have autonomy, and at the end of it all, they are the ones who are going to make the decision. We stand in as facilitators. We don't make decisions for them, but we help them when they've reached an impasse to look at the points, the issue from a different angle with a view to settle. We help them as much as possible, but at the end of it all, it's up to them to settle. We use our different skills in coaching, negotiation, and just helping them look at the matter from different perspectives to help them settle. There are times we actually have caucuses whereby in the process of a mediation, we can actually divide the parties into two different rooms. You find that as an arbitrator, I'm not allowed to see the parties separately. But in mediation, I can see the parties separately and negotiate with them and ask them to really look at the point, the issue from different angles and see if they can resolve. Then from there, you go to the other room and you see where they are stuck. And you kind of negotiate and just tell them, what do you think about this? Okay, that's what they have said. Okay, you don't tell the other party what the other party has said, but you listen to what they are saying and you help them move from their maybe very stiff position. Because in mediation, you're not looking at the legal issues. In mediation, you're looking at the interest of the parties, trying to get to the interest of the parties. And usually once you get to the interest of the party, usually that party can be solved. How do I explain what an interest of the party is? Very simple, something very common that you have repeated over and over again is in the case whereby you can find two people fighting over an orange. And you need to find out, why are they fighting, or why do they both want to get this orange? And once you get to know why they want to get the orange, that is the interest of the parties. Usually from then you can solve a dispute. So you may find out of these two parties, one of them maybe is a baker and simply wants the cover, the casing of the peels of the orange to add flavor to their cake. Another one could be a mother who wants the juice for the baby. So you see, instead of now cutting this orange right in the middle, you get to give the person who wants the peels, and the person who wants the orange, the juice. And usually once you do that, you get to solve the matter. You get to help them solve the matter. And basically, at the core, at the very fundamental, that is what mediation is. As we facilitate, we get to really know what really is the issue of the people that are disputing. There is one case that I dealt with, and it was a family, some kind of family, some property and all that. And we were in court for some time. It was the legal aid week, I believe. And so after I listened to both the parties and I brought them together, I asked the lady, what exactly? Yes, you have come and you've complained about 1, 2, 3. What exactly do you want out of this? Yes, you've come to court. You've come now. Now we are at a mediation. Tell me, what would you really like to get out of this situation? You can't believe it. From another town to another town, he said, all I want is for them to ask for an apology. I asked her, that is all you want? Yes. That is what you want? She said, yes, that's what you want. Would you allow me to tell the other party that that is what you want? She said, yes. So when I went for the caucus on the other party and I listened to them and I told them, by the way, you're in court over this with your children and there's a lot of hullabaloo, but would you have a problem asking for forgiveness? She said, no. I asked her, are you sure you don't have a problem to ask for forgiveness? She said, no, she doesn't have a problem. So I said, fine, okay. So I have on one side, I have learned that they want to be asked for forgiveness. On this other side, I've learned they want to forgive. And mark you, that case was so bad, it was involving them in traveling in and out of the country because they're different from different parts of the world. So I got them back together and I asked, so madam, so we've come here and what do you have to tell this lady? She said, I asked for forgiveness. So I asked, and you, what do you feel about that? She said, I'm cool with that. That is what I want. We did a consent. We finished, you see. And you see, this is a matter that had been in court for a while. I think this one had been in court for about 2-3 years. So as a mediator, you get those skills to get to see what is the root cause. And once you have identified the root cause, then usually you can help the parties. And sometimes there are times you can do it when they are together. There are times you have to do it when they are apart. But eventually you bring them together and they conclude. So the challenge that I've had, sometimes maybe I'm looking at time because I don't have so much time. One of the biggest challenges I've had. Sorry,
Phyllis, you have 1 more minute to go. We have to take questions because Lydia has to leave.
Okay, so fine.
Thank you.
So just a quick one. One of the biggest challenges I've had and most recent is when the senior lawyers don't want to sign the agreement. There was one matter whereby we agreed on everything and it was online. So when I sent to them the document to sign, refused to sign. And they said, that's not what we agreed. And I remember that lawyer at one time had referred to another one as being cantankerous. And I was like, gosh, this senior lawyer, aren't you the one of being cantankerous? Those are some of the challenges you have as a mediator, whereby the parties just put on interesting hats and they don't want to sign. And you don't see why they can't sign, but we try our best to help them sign. So other than that, just as we have mentioned, as at Women in ADR at the moment in August, we shall be having a moot court in with the USIU, courtesy of our patron, Lady Justice. And we shall be equipping the students to prepare them for the outside world on how to deal with dispute resolution. And we shall be looking at mediation this year. And we are having universities that are coming from all over the world. And for me, what I'd call out to any of the participants who are here today, if you are capable of being a judge, please apply. Thank you very much. Thank you. Have I done justice to 1 minute, or I can talk a little more?
Thank you so much, Phyllis. Thank you very much for sharing your experience with us. Before we take the last speaker, please, would like to take questions and answers, most especially those directed at Lee J. Berman, because he has to leave. We'll take Adewale Fajano right after Lee J's questions. Thank you. I'll be handing over to Victoria, who will be handling in Q&A. Thank you very much.
Good afternoon, everyone. Hope we've learned from the 4 speakers that have spoken so far. It has actually been hope everyone can hear me. All right, that's right. All right, that's fine. Thank you. So it has actually been quite insightful listening to Lee J. Berman, to Honorable Justice Caroline Kandakor, Mrs. Achere Cole, and then Mrs. Phyllis Wangwe. And one key takeaway for me is the fact that the process has to be reassessed from time to time. But let's quickly dive into the questions that have been asked. At this point in time, we just take the questions directed to Mr. Berman, so that Mr. Berman would leave at the right time. So we have 4 questions, Mr. Berman, from your presentation. And the first one is, what motivates the parties to go for court-annexed mediation in your jurisdiction when they pay the mediators by themselves, considering the fact that they also pay lawyers legal fees? So the question is just basically, why would parties or disputants want to pay mediation fees when they've already incurred legal fees?
It's a great question. And I think one of the assumptions that I was making that I should be clear about is that in the United States, lawyers don't typically work on a flat fee basis as they do in some other places. Here they get paid by the hour, or they work on what we call a contingency. So they're collecting a portion of the recovery if they're representing the plaintiff in a case. So, pardon me, mediation generally helps cases resolve earlier in the process without the need for full-blown trial preparation with discovery and depositions and all that sort of thing. And so the idea is, if they can get a case resolved early in the process, the fee that they might pay the mediator, at least in our marketplace, is a very, very small percentage of what they would continue to pay the lawyers to take the case all the way to trial. Here, the attorneys in the United States can be very, very expensive. And the legal process can cost $100,000 or $200,000 on a big commercial case or more. I've had people sit in front of me who have spent $1 million collectively in legal fees before even coming to the mediation, let alone what they would spend afterwards if the mediation wasn't successful. So that's part of it, is the proportionality of the mediator's fees compared to the eventual legal fees. But the other is, if they have a complex case and they want to resolve it and they don't want it to go on and on in a litigation process, they want to hire somebody who, like some of the other speakers have said so eloquently, who has expertise in that field, or who's appropriately situated, whether it's does that IT implementation, was it complete or not? Those are great examples. And in cases like that, they want to hire somebody who's a specialist and who is an expert to them. So I think those are some of the motivations of why people would pay a mediator after they'd already paid legal fees.
All right, thank you so much. So I think my takeaway from that is it's actually more cost effective. It's one of the more cost effective ways to resolve the disputes rather than taking the disputes all the way through litigation. All right. The second question is, what is the basic qualification for a court mandated mediation? But I think this should be for a mediator to qualify to mediate in a court mandated mediation. And a corollary question to that is if it's mandatory for mediators to be lawyers is it mandatory for mediators to be lawyers in the United States?
No, not at all. Let's see, taking that second question first, what we found is that when the courts started sending such volume of cases out from the court system into mediation, then mediation became much more legally oriented. And this happened in California 30 years ago. So where mediation had been a grassroots effort, and I love the way that all the presenters have spoken about mediation today, it is about the parties' interests, and it should be. And it is about the parties' self-determination, and it should be. What happened in our county especially, given the numbers of cases we discussed earlier that are going through this mediation program, is they became much more like settlement conferences and dollar compromises without mediators being skilled enough and frankly, attorneys being willing enough to let the mediator delve into the party's interests and what other non-economic solutions and other things might be possible. So the one caution I would give everybody else who's listening to this is be mindful about letting mediation, I think, devalue by coming just a trading of numbers back and forth with no other discussion, because then it's not really mediation anymore. So you don't have to be a lawyer. I'm not, and I've done now 3,000 mediations. But I think it's important to make sure that the process stays as pure as it can be. And in terms of what the qualifications are, it varies widely by jurisdiction, from as little as a 25-hour course and nothing more to up to 100 hours of training with letters of recommendation, where a court administrator will call the lawyers who are vouching for the mediator and interview them about the mediator's qualifications before letting someone on the panel. So it really varies widely, and I'm encouraged to hear the very, very thoughtful ways that Kenya and Nigeria are thinking about their mediators and the qualifications and the matching and pairing of those mediators. I think pairing the right mediator with the right case is one of the most important variables. And whether that decision comes from the parties or a very well thought out process like we've heard here, where they're being matched for all the right reasons, I think that's one of the big variables that's important. And again, if that pool of mediators has had more training and is better qualified, then I think you'll find a much higher success rate and satisfaction rate, which is the real measure of a successful mediation, because you'll have a process that the parties feel like they're being guided through by somebody who has training and experience and can help them explore all the things that may be going on underneath and that really need exploration. So I think that's why the training is so important, as well as the right matching or pairing.
Thank you so much. Well, I think I'll keep one of the questions and go to the last question because I'm being mindful of your time. Two people asked two different questions, but it's basically the same question. So the question is actually directed to both yourself and Honorable Justice Kendago, but we'll take your views right now, then afterwards we'll take the Honorable Justice views. So the first question is, I know you've addressed it during your presentation, but like I said, it's 2 in 1. So the first question is, in the US, how do you ensure parties and attendance in a court-mandated mediation where one party, after submitting to mediation, refuses to attend mediation? So I think the part A of that is, does that happen during at mediation sessions in the US? And as a corollary to that is how the courts handle situations where a party is unwilling to submit to mediation. Are there sanctions?
Yes, there can be. That's all up to the discretion of the judge who made the order. I will tell you, in the US, attorneys don't attorneys highly respect a judge's order and will follow and comply with that. They don't tend to snub those and say, no, I'm not going to go. If they're ordered, they'll show up. So the next problem that can follow that is they show up with their arms crossed and their briefcase closed, and they say, I'm only here because the judge ordered me. In which case we turn around to sort of convening the mediation again and trying to find what their interests are in the potential of resolving the matter sooner rather than later, and using mediation to help do that. And so we continue to sell them on that process once they're there. The other thing that I like to do, and some of the judges may not like this, but it works as well as anything that I have found, and that is, I'll say to them at the end of my introduction at the top of a mediation that introduces me and the process and all of the sort of administrative concepts, at the end of that, I will say, and to the degree that you were ordered here by a judge or are here by a clause in a contract that mandates your participation in mediation, as far as I'm concerned, you're dismissed. Just having shown up and listened to my introduction about this process and coming here with everybody else satisfies the requirement. So if that's the only reason that you're here, you're absolutely free to go. And we're all going to take your continued participation here as a desire on your part to work toward a resolution of this matter, and we'll continue to do that for as long as everyone is here. I've never once had anybody pack up and leave when I've offered them that invitation to leave. I had one gentleman one time who looked around the room and he slammed his binder closed and said, "We're out of here." And then he looked around at everybody else and said, "Just kidding," and broke the ice in a way that I could never have as the mediator. But by turning a mandatory mediation into a voluntary one, making them realize that they're here because they want to be here, that helps the mediation progress very well. But I've never had the experience of parties saying, no, I refuse to come to a mediation, even though the judge has ordered it. They're good questions, but we don't see that problem here. And I think it has to do a lot with the strength of our justice system. I think, I've heard other countries, post-war Germany and things like that, where the judges aren't as respected as they deserve to be. And I can tell you in the US, if somebody's ordered to something, they better go or there would be sanctions.
All right, thank you so much for your response, and I really love your the fact that as part of your introduction, you always slip in that phrase as regards you're free to leave, and for me that's a reverse way of as a working on the psychology of the disputants as well as their lawyers. And thereby getting their buy-in, because you've told them what mediation is about. So you've turned their resentment into a buy-in into the process. Thank you so much, Mr. Lee J. Berman, for your time and for your insightful discourse.
Thank you. I'm so sorry that I have to run because I've so enjoyed the other presenters and would love to hear their answers to the questions too. So I'm hoping that I'll be able to see the recording afterwards.
Yes.
But thank you so much, Simi, and everybody for having me, and it's been a great pleasure. Thank you.
Thank you very much, Mr. Lee. Thank you very much. So we'll be moving on right to Mr. Adewale Fajano. He'll be sharing with us briefly his experience with court-mandated mediation as a lawyer.
All right, thank you very much. It's a pleasure to be here, and I've had a good time listening to the presentations by other speakers. I'll just touch on maybe one or two issues from my experience as a private legal practitioner, and that will be it. So for me, talking about voluntariness and compulsion, I wanted to just highlight, some thoughts and, some of my experience, particularly from the standpoint of legal practitioners who get to represent clients in mediation and other alternative dispute resolution proceedings, particularly in mediation. Of course, the first conversation is the fact that there is a cultural attitude to dispute resolution, particularly in cases where there are no express provisions in the contracts of parties or in the absence of settlement agreements to refer possible disputes to resolution. So sometimes you see parties like the last speaker just said in the answers, most people just don't want to, submit themselves to mediation in the absence of, express provisions in their agreements, or, further to the decision of a court to mandate a mediation process. And of course, you would see parties saying, I'm just here because the court says we should be here. Even some clients, sometimes, show you that, lawyer, this is not what I want. I want to go all the way through a litigation process and referring me to a clause in my contract that says I must go for mediation, or the court deciding so moto to refer us to mediation is definitely not what I want. Because there's a cultural standpoint to dispute resolution. There is an intention to perhaps prove a point, and use the adversarial system to ensure that a point is proven or justice is sought, So that's one key thought. Sometimes where there is that absence of an express provision within the contracts of the parties, you see that attitude. And for me as a legal practitioner, the first point is to ensure that I educate my
Yeah, muted.
Can you hear me?
Yes, we can hear you now.
All right, to explain to my client that, one, the court has the powers based on the provisions of the rules of court, and then perhaps if there is an express provision in the contract or any other defining transaction document or agreement between the parties. One of the things I've also done was to get a party on the other side, after the court had given an order to go for mediation, to come together and sit down and execute, a settlement agreement, all right, wherein we decided the rules and the foundational principles under which we would go to or a mediator to seek a settlement, all right, where we expressly agree, after the court had ordered us to, go for mediation, where we expressly agree, to satisfy that ground of voluntariness, so that a mischievous legal practitioner or a contentious party on the other side do not hinge on that to challenge the mediation process, and then at the end of the day frustrate the intentions of the parties or the orders of the court. So that's one key thing I wanted to mention. All right, and then that also talks to the attitude of legal practitioners. Of course, the concerns around the quality and the training of both mediators and legal practitioners to participate in the mediation process, it's one thing. right? One other thing I've seen is that many lawyers have the attitude of resistance to mediation, resistance to enforcement of settlement agreements, even after parties had collectively agreed to reach settlement. And then, of course, so we still have these issues of adoption and resistance, where parties want to resist and not voluntarily want to, ensure that the intention of the court in getting the parties to resolve their dispute within a faster period, at lower cost. Some lawyers will even tell you, this is an additional brief. I want to get extra money for going through the process of mediation because that was not what I intended. And sometimes the argument is whether it's a three-pronged process whereby you first go to court, then you go for mediation, and after mediation, go back to court to ensure that you are able to enforce the whatever settlement agreement is reached between parties in the process of mediation. So these are some of the thoughts I just wanted to highlight. Most of the speakers have talked about confidentiality, instances of delay and increased costs, appropriateness of referral in terms of the subject matter of the dispute between the parties, and then of course sometimes the issues of legal framework, all right, particularly in states and in areas where there is no defined or strong. If you are outside Lagos, if you are outside Abuja, and maybe Parakot, and some of the states that has set up there are perhaps multi-door courthouses or have rules that allows them to apply mediation, to disputes, particularly from where the courts refer, parties that has come before it to go for mediation. So you see a dearth, of both knowledge, expertise, across the country, and that becomes an issue of thought to encourage lawyers to familiarize themselves more with mediation principles, processes, and then of course ensure that they, achieve the objective of quicker, faster, and cheaper resolution of the disputes that their clients might have brought to them, particularly where the court, gives them an option to go to mediation, or where the contract or defining documents between the parties allow them to do so. Thank you very much.
Thank you very much, Mr. Adewale Fajano. Thank you for sharing from your experience. And one thing that stood out for me is, where the court has referred the parties to mediation, the lawyers coming together to draw up a submission agreement. This, it really works. I think that would work and would up the attitude of lawyers during the mediation procedure. Thank you, everyone. We're going to move on to the Q&A. Victoria will take over from here with the questions. Thank you. And we're going to release the last set of polls as the questions are going on. Just answer the poll questions and, well, Victoria, you can go ahead. He's not going to.
All right. Thank you so much, Simi. And thank you so much, Mr. Fajano, for that interesting and insightful intervention. All right. So particularly what you said about as a lawyer, the role you play with, I think for me, what stands out is the fact that you've taken ownership of the process, even beyond the court directing or parties to go for mediation, because you said something about educating your clients. So that means you start with your client objections to mediation. So for me, that really stands out because a number of lawyers don't even know how to respond to their clients' objections to attending mediation. All right, so we'll dive right into it. And I thank you so much, our beloved participants, for staying with us these 5:10. So we'll quickly run through the questions. I think in all we have 12 questions, yes. So I'll start with Honorable Justice Caroline Kendagor. Your Lordship, we have 4 questions for you, but I'll mix it up. So the first question I addressed to my Lord is, how long is the pre-mediation meeting in Kenya? And are pre-mediation meetings in Kenya in person, over the telephone, and then also are parties engaged jointly or separately? So the question revolves around pre-mediation meetings.
Thank you, Victoria, and thank you, everyone. It's very interesting conversations. So in Kenya, the period from the time the mediator is appointed or from the time when the mediator accepts the appointment runs for 60 days. We realized that there was some time that was taken up in terms of the communication, the transmission of the file from the court that is referring, all through now to the period when the mediator is appointed. So in the new, when we, after the pilot, we changed the period. So the 60 days run from the time the mediator accepts the appointment. And then for the mediation sessions, they're hybrid. We have some that go purely physical. Others have a hybrid of online and physical sessions. And then I think those are the first two, Victoria.
Yes, the follow-up questions to that is, are parties engaged jointly or separately during
It depends with the mediators and the disputes. So in terms of whether they opt to have the pre-mediation either jointly or separately, that one is within the domain of the mediators.
All right, thank you so much, Your Lordship. Before I move to the next participant, I would like to ask you the question, the last question, set of questions Lee J. Veman attended to, because the question was directed to participants from speakers rather from both US and Kenya. And I think Your Lordship will be in a better position to handle these questions. So the first question is, how do I think as a judge now, how do you ensure parties' attendance in a court and next mediation, where one party, after submitting to mediation, refuses to attend mediation? And also, how do you how do courts handle situations where parties are unwilling to submit to mediation? Are there sanctions in Kenya, particularly because you've told us that there is no legislation that backs up mediation in Kenya? Rather, what you have are policies and court rules developed from the Constitution.
Thank you, Victoria. So as I mentioned earlier, one of the things that we, out of reflection and seeing how the uptake was and the success of mediation was, and of course the measure about the issue of compliance, is we started mentioning the matters before referral so that there's an explanation to the parties. And that was from a learning curve of the high non-compliance rate that we were having, where parties would fail to submit. And we realized that a lot of the submission, even as we were looking at it from an external point of these are parties who are just refusing to submit, was also a reflection in terms of, are we expecting that they already know what this mediation is about? Do they understand what their roles and responsibilities are? So when we started mentioning the matters, the non-compliance dropped. The other thing that we also do to be able to address the issue of non-compliance is the active case management. So once a matter is referred to mediation, there's an active case management that is conducted by a deputy registrar, a judicial officer, who then keeps a check with the parties, and the mediators file periodic reports. So these reports then are able to inform you that there's a laxity on the part of one party. And during the case management forums, you're able to engage with them and ask them, you've not been attending, is there a challenge? Is there anything that perhaps we can do to support you to ensure that you are attending the mediation sessions? And out of those, then it gives you again another opportunity to continue engaging the parties, explaining to them what are the expectations, and ultimately you have that. With that, they submit to the process. The rules that we have penalties for parties that fail to submit to mediation. Some drastic, for example, a judge can strike out the pleadings of a party who fails to submit to mediation. The court can order that you pay some costs, so it can fine you monetarily. And then number 3 is the court can still make an order sending you back to mediation. We've exercised the last one of sending the parties back a lot more. We've had instances where parties have been fined for pleadings because I think coming in from a measure still that there's a lot of sensitization that still needs to be done to get to a level where you feel like the parties really understand what the process is about and what their roles and responsibilities are. But in instances where you have had those sessions, you feel like the non-compliance is really out of an instance to just frustrate the court order, then the courts can still go ahead and make the orders that are that include the striking out of pleadings. Thank you. Back to you, Victoria.
Thank you so much, Your Lordship, because that's really interesting. And what sparks my interest is what you said about an active case management, which enables the secretariat to follow up and then even engage in advocacy with both disputants and their counsel. I think that's really fantastic. And of course, I actually love your sanctions in Kenya. Yeah, I don't think we have the time because I have follow-up questions as regards the sanctions. So I'll quickly move to Mrs. Cole. So Your Lordship, just give us a few minutes to ask the other participants questions. Thank you. Mrs. Cole, there's a question addressed to your good self as the director and the CEO of the foremost African court-connected multi-door court house. And the question is, if you were to design a court-connected ADR program from scratch, what would you include or avoid?
Thank you, Victoria. This person is asking for free consultation. But it's all right. That's why we're here, to make sure things, are done well. First thing to include sensitization. You can imagine the conversations we're still having till now. That how many years after, 20 plus years after, we're still sensitizing the bar, sensitizing the bench. So that's number one. That is, at the beginning, it's ongoing, it's futuristic. And sensitization cuts across the bar association, the bench, the communities, institutions. It's so broad, and you can never have enough of it. Another key thing is to, from the get-go, get expert mediators. Don't stint on this at all. You need very strong hands. The success of the court annex mediation program is sinks or swims based on your mediators. You need very strong hands. So you get those expert mediators who also understand ethical behavior. I'm very particular about that because that's what the parties look at when they see you. Then you need a law. You saw what we said at the beginning for Lagos. We started in 2002. We didn't get our law to about 2007. But you need that law. It's a guide. And you need the rules to guide you from the beginning. So if you have that plan, start working on your rules and your law and all of that. Then you need a location, definitely. Where are you going to house it? But don't be too worried. Lagos Multi-Door started with 2 rooms. You can imagine 2 blessed rooms. And we've grown over the years. So don't worry about having so much space, but just have enough rooms to have mediation sessions go on. You need a good location for the parties to come to. So those are the few things that I would say that you should have way more beyond mediators training. You also need staff training. You don't need many staff. We started out small, but you need good hands. You need really good case managers that can manage the case end to end, and you must train them. Send them for training. You don't have to go for any expensive training. They can get training online. Multi-Door even does simple trainings. You have free trainings that you can attend. So make sure that they get that case management training. Then something I feel is a huge learning curve, and it's happened in Nigeria. I've heard it in Kenya. I've heard it in the US, is you need to sort out this issue of payment of mediators. There's no way you can run a system that is sustainable without sorting out paying the mediators. We are all, well, I mean, quite a number of us on this call are mediators. And the what we pay our mediators is abysmal, it's ridiculous. We need to sort this out from the get-go going forward. How do you plan to pay the mediators? Not this voluntary approach. Meanwhile, you are resolving cases that are in billions, but even a percentage of the billion is not coming to the mediator. So you need to work on a fee schedule that ensures that the mediator gets a percentage of the settlement. Well, that's a proposal. You can come up with what you want to do in terms of sorting out mediators' fees. And then for what to avoid, of course, just the opposite of the things I've said. Thank you very much, Victoria.
So much, Mrs. Cole. Before you go, one more question. But for me, really, of course, okay, like Simi said earlier, of course, Mrs. Cole is also my boss. So I understand most of the things you said. But I think some of the things that stood out for me are not just good mediators, but ethical standards must be maintained at every point in time. And for me, I think that what resonates is the fact that one bad egg actually spoils all. So a poor experience at mediation could have a far-reaching impact, could actually undo several years of good work that the organization had accomplished. So thank you so much. And of course, a good fee schedule that would motivate mediators. It will help them put their thinking caps on. Thank you so much, Ms. Cole. And then one more question. Somebody wants to know, or one of the participants wants to know, does the LMDC enforce mediated settlement agreements?
Well, we help with the process. So it's only the courts that can enforce, right? So we will help with the process. And what we have done over the years is that we now ensure that the party who has to pay signs an affidavit of no contest. That we didn't have that in the beginning. So from the get-go, you sign that affidavit of no contest. So we do help with that entire enforcement, but the ultimate enforcement belongs to the court. So what happens now is that when the cases for court-referred matters, it goes straight to the court, isn't it? So that automatically becomes, judgment of the court. It's for the walk-ins that are not within the court system already that need that process to be taken care of. So if you walk into the center, then we help with the enforcement process. And then with the endorsement, let me clarify that. I hope I'm clarifying this. Is the endorsement how you get the terms endorsed and back into the court system through the originating processes and all of that. We assist with that process, and then you can walk in from anywhere. Even if you are a center and you are not court connected, you can walk into the Lagos Multi-Door Courthouse and we help with that endorsement process also to get you to the point of enforcement in the courts, but we don't do the enforcement itself. Okay, thank you very much.
All right, thank you so much, Mrs. Cole. So we'll quickly move to Mrs. Phyllis Wangwe. Mrs. Wangwe, are you ready for me?
Yes, I'm here.
All right, thank you. That's lovely. So the first question is the point Mr. Fajano came from, which is, as a mediator, how do you address objections to a court-connected or court-mandated mediation, particularly from your wealth of experience?
Okay, objection from what context first?
Okay, from disputants of counsel who are reluctant to participate in the mediation session.
Mediation. Okay, it varies. It depends on how it's how it's brought up. Because for one thing, as a mediator, you must be neutral. And you must not just be neutral. You must not just be neutral. It must be very clear that you're very neutral. So you can't afford to look like you're taking any side. So there was one case, for example, that when it came to my attention, there was no contact of the other advocate. So I reached out to the party and tried to explain to them what mediation is all about and why they should not be worried about it. Okay. But somehow they did not get it right, and instead accused me of knowing too much about them, forgetting that I had read the case summary. So that one, I withdrew. They begged me to continue with it. I said, you see, by the time I'm getting into a mediation, the parties must have confidence in me. Now, when you're not having confidence in me for one reason or the other, let somebody else who has not dealt with it, deal with it. Otherwise, now that is one. And that was, for me, that was a direct attack. I felt like, no, this is not starting on a very good foundation. That's it. Otherwise, what we do is we explain to the parties. We explain to the parties why it is important they go through the mediation. And we tell them they do not have to agree. It does not mean they'll agree. We are very open to listen to both sides and just help them navigate and come to a conclusion. But in the event that they don't, it is not binding on them. What we bring up is, as Lady, where is her name going?
Yes, Honorable Justice Kendago
Has just said, there's that enforcement, but we usually try not to reach there. Sometimes they are not aware. So we just try to make them really be aware of the process and tell them that, by the way, at the end of it all, they're likely to benefit, because mediation, the way we approach it, is always a win-win for all parties. So we make them understand, try to make them understand that it is in their own interest that they get into that mediation. They'll get an issue addressed that would probably take 10 years in court or 5 years in court. Why don't we sit and agree within 2 or 3 months, as opposed to you going to court for another 3 to 4 years and you're not even sure on how it will end up? So
right, thank you.
That's what I do.
Thank you so much, Mrs. Wangwe. Though I can see that time is far gone, so we need to move fast. So one question for Mr. Fajano, then I think we'll just take one last round of questions or general questions, as the case may be. Mr. Fajano. Okay, so you've told us how you address objections from clients and all that. But as a lawyer, how do you address objections from the opposing counsel, who does not just like the idea of participating in mediation?
All right, thank you very much. So yes, typically my approach to objections from the opposing counsel most times is to, one, ensure that he understands that this is a position, particularly in court mandated mediation proceedings, is to, one, this is the position of the court, and then of course to outline the benefits in either personal conversations with the counsel on the other side, with the consent and mandate of my client, and then of course try to seek that level of understanding to say this is the benefit or the advantage that this process affords us, and then of course now have conversations about agreeing to appoint a mediator, or where the court appoints a mediator, to bring out the benefits, particularly, for instance, in maybe matrimonial cases where there are concerns around custody, education of children. You want to bring out the value of mediation, right? To say these are the issues, this is the advantage, particularly to the children, because the interest and the welfare of the children, often that's one of the areas where I've had similar, objections from the counsel on the other side, where I'd had to draw out the benefits and the advantage of the mediation process to the counsel on the other side, and it was something that really worked, for us to achieve the best interest of the parties, like it was said that it's a win-win for parties. It's the benefit in terms of speed of disposition of the matter, in terms of time, and then of course cost concerns, and the overall interest of justice for the parties that are concerned or impacted by the mediation process. Yeah.
All right, thank you so much, Mr. Fajano. I think I'll take one last question directed at Mrs. Cole. Then we have 3 general questions which can be taken by any of the speakers. So, Mrs. Cole, a participant wants to find out, how does one become a neutral at the LMDC after concluding their mediation skills training?
Okay, you can apply. Particularly now we're taking, send an application to email. You can get an email on our website. Particularly if you have a specific area of expertise. That is the vacancy we have. So if you have expertise in insurance or telecommunications or oil and gas, those kind of areas, maritime, those are the kind of things, banking, and not just banking, specific areas in banking now, because we're having quite specialized cases coming in. So those are the kind of applications we're looking to get. And of course, you must have the requisite training, as the person has said. Thank you, Victoria.
All right, thank you, Mrs. Cole. So the first general question, I think I would like either Mrs. Cole or Honorable Justice Kendago to attend to this question. How important is judicial support in building strong court-annexed mediation programs? And what approaches have been effective in getting judges to fully embrace mediation as part of case management? Or we could do 2 minutes each. Mrs. Honorable Justice Kendago could go first, then Mrs. Cole next. All right, I think while we are waiting for Justice Kendago to unmute herself, Mrs. Cole, do you want to take this?
Can you take the question again, please?
Okay. How important is judicial support in building strong court-annexed mediation programs? And what approaches have been effective in getting judges to fully embrace mediation as part of case management?
Okay, so judicial support, yes, quick one. Yes, we need judicial support. It's court-annexed, so definitely you need the complete buy-in of the judiciary before you can have court-annexed mediation. And sensitization, we do a lot of workshops at the beginning, now, in future, we do a lot of workshops where it's not just about the court understanding, but we understanding the needs of the court too. So it's a symbiotic relationship where the court needs to know what is necessary. We need to know what they need, So that is what we have done over the years, constantly engaging with the judges, with the magistrates to find out what their needs are, and they engage with us to find out how we can make it more seamless. More than ever now, we're looking, like I said, to see how to make it so seamless that you don't have to have lawyers walking into the center. That's where we're headed, where, from wherever you are, you can file and move your case forward. So yes, judicial support is very important. Without it, you really can't do anything because you're court connected. So that's
all right, thank you. Then there's a follow-up question, or rather a part B of it, which is how have you been able to get judges to fully embrace mediation as part of case management?
Oh, same advocacy. And of course, one thing about judges, I'm sure my Lord Justice Kendago can testify to that, is that they work with the law, they work with the rules. If you can show them the law and show them the rules, they buy into it. As long as they know it is in the law and in the rules. Our experience is that they buy. It's only when it is not well documented and they complain that, no, I can't see the relevant provisions. And then, of course, a lot of advocacy too. And that's just been the engagement. But I can tell you that the bench in Nigeria has been exceedingly supportive of the ADR process. Thank you.
Right, thank you so much, Mrs. Gold. Justice Kendago, do you want to take this on?
Thank you, Victoria. Thank you, Mr. Cherry. So in addition to what Mr. Cherry has mentioned, one other thing apart from just the institutionalization, ensuring that all the tiers of our administration, including those who sit in court and the administrative wing, getting them to really understand what you are doing and that you are running on the same objectives with the judge who is sitting in court. And then we also got the leadership, especially of the tier of courts, to have to adopt mediation as a standing agenda item in the leadership and management team meetings. So the same way, like there's a report that is now presented about how we are faring on in terms of case resolution, making it a standing agenda item that you also report on how we are doing on matters mediation. Then again, making it a standing agenda item in the stakeholder meetings. And then the other bit that was also a game changer for us is that we moved away from the sensitization now to training the judges, the magistrates, and the cadis as mediators. That even if they are not mediating, they have the opportunity of being of going through the training as mediators. We had greater buy-in. Now we have better explanations when we are having the referrals, so that when you're even engaging the parties and you're telling them, I'm sending you to this process, as a judge, as a magistrate, as a cadi, you know what this process entails. And it really gave us a greater buy-in in terms of the referrals, but we've also seen a greater interest now by the judges and the judicial officers on matters mediation.
All right, thank you so much, Your Lordship, because really, I think the idea of training judicial officers as mediators would give them a better understanding and help in tackling even objections to referrals to mediation. So one last question that I think Mrs. Cole and Justice Kendago will be in a better position to tackle these two questions, which I'll merge. The two questions are: what types of cases are most commonly referred to mandatory mediation in Nigeria and in Kenya? I know that in the course of your presentations, you had highlighted those types of cases. And then secondly, how do courts in each country, that's Nigeria and Kenya, monitor compliance or implementation of agreements from a settlement, implementation of settlement agreements from mediation? So Justice Kendago, you can go first. 1 minute, please. And then Mrs. Cole, 1 minute. Thank you.
Thank you. So on the implementation of mediation, we have a digitized case management platform that assists us to just have data about mediation. So we do not close a file until when you get to the last point, which is payment, which does not happen until the settlement agreement has been adopted. So just to follow up, maybe in terms of the presentation, we moved away from having calling parties to come to court to before we can adopt, because we realized it was taking a very long time. And then sometimes we'd have instances where the parties would come and somebody, before you adopt the settlement, say that I've changed my mind about it. So we started adopting them in chambers in the absence of the parties. And then now we extract the decrees and the orders like we would if it was a judgment or an order of the court. And then now the monitoring in terms of implementation, we leave that to the parties, but I can very happily report that we do not get cases where parties come back to say that they want to have a forced enforcement of the settlement agreements, which of course we give credit to the fact that there were consents that were agreements that were recorded in mediation, so parties willingly comply, which would be the opposite of what would happen with the orders and judgments of the court, because you'd find that our cost list would be half of them are cases that you are following up on notice to show cause, you are following up on execution. Those are the stopgap measures that we're just doing to give a soft landing to the recognition of the agreements, the adoption, and then the extraction of the decree, so that in case anyone wants to enforce, they're free to go on. Vicky, the other question was on.
Okay, the types of cases are mostly referred to mandatory mediation.
Thank you. Now we refer all cases. Initially, we were holding back about criminal cases, but we realized that the few ones that we had were registering very successful rates, but of course with a very measured manner in terms of the handling of these criminal cases, referral to mediation, because unlike the civil cases where we can screen and refer from the registry and then bring them to court, where there are criminal cases, we leave them only to the discretion of the judges and the magistrates for their referral. But we have registered very, higher success rates in family disputes, which would cut across for succession, custody and maintenance matters, division of matrimonial property. But we also have very interesting areas that are now coming on board. The Employment and Labor Court are becoming champions. And then we also have cases that are coming from the Environment and Land Court. Thank you.
Thank you so much, Your Lordship. Reading. Mrs. Cole?
Okay, so for settlement agreements, particularly what we've done is to ensure that the agreements, because that's where it starts from, is to ensure that the agreements themselves are well drafted. Now, what I mean is that's where the monitoring begins. Who signs those settlement agreements? For the corporation, sometimes we insist on having a seal so that nobody can renege, down the road and say, no, it's not my deed. So that's where we are very particular about who signs those settlement agreements. Then when it gets to the court, what Nigeria has done, the judges insist that the parties, both parties, and it's also in the rules. So even after the multi-door is done, the judges insist that both parties appear and say that it is their deed so that they cannot plead non-ex factum later. So that's very key to monitoring. And by the time, the experience we have is by the time they enter those terms in the court, they typically would abide by the terms. Of course, you have those that will renege, but we don't monitor to the point of payment, as I'm hearing Kenya does. We don't do that. Once we're done with ensuring it's appropriately signed and the parties agree that it is their deed, then it is the party's responsibility and the enforcement process takes place going on from there. Then for the cases that typically get resolved, isn't it? Mostly commercial disputes, you can see, pardon?
Referral. The type of cases that are commonly referred.
Oh, we have a broad range. We have such a broad range of cases that come to the Lagos Multi-Door Courthouse. I think I mentioned the maritime, building and construction, landlord and tenant, matrimonial causes, administration of estates. They're just such a broad, practically any civil kind of case you can mention is coming into the multi-door. Electricity issues have started to come in now with the new tariffs. So those are new ones that we're beginning to see. New cases we see are these issues with development of estates. Those are the new cases that we're seeing more and more. So they're just a broad range of civil disputes. Thank you.
All right, thank you so much, Mrs. Cole. And then lastly to Mrs. Wangwe and Mr. Fajano, as the lawyers who are also mediators, I would like to find out, or rather, some of the participants would like to find out what has been your experience, both as from both sides of the spectrum, being a lawyer, in a court-mandated mediation, and also being mediating, mediating court-mandated cases. What has been your biggest challenge in conducting these mediation sessions? So, Mrs. Wangwe, 1 minute, and then Mr. Fajano, 1 minute, please.
Like I just explained, thank you once again for the opportunity. My biggest challenge is when I get fellow lawyers who are not cooperating.
Yes.
Because the truth is, a lawyer has a big effect on the clients.
Yes.
So once you have a lawyer who is cantankerous, let me use that word, or is not helping the clients have a neutral perspective, it becomes very, very difficult. But when we have lawyers who are easy and maybe can just sit back and let you move with the case, it becomes easier. Because I've seen there are times, again, you even agree. I mean, once the parties are seated and they talk and agree, they say, let me refer to my lawyer.
Yes.
You cannot stop them from doing that. It's their right.
Yes.
And sometimes they just come and scuttle the process after that.
Mm-mm.
The lawyer does not even have to be in the room. But I think sometimes they threaten some of these clients. And the other part that I usually find a challenge is when a client comes in, a party comes in that already has preconceived mindset.
Mm-mm.
And like there's one matter we got into it and they got a very good settlement and all that. And then she asks them, she tells this other party, why don't you give me the property you have retained? And this was a succession matter that had gone on for over 20 years. And she's just like, I don't care. Even if I go to court and the court just gives me a drop or a fraction of what I'm getting here, so be it. You see, that becomes very, very unfortunate, you know, and you don't know sometimes where some of this negative energy comes in. That can be very challenging. That can be challenging when somebody has a preconceived mindset and they just don't want to move, and they're believing that court is the verdict from the court is what matters, is what is honest, and is what is right. That becomes a challenge.
All right. Thank you so much, Mrs. Ongwe. One final question for you before Mr. Fajano takes on that question. Somebody wants to know, I know you've answered in the chat, but for the benefit of those who didn't see your response, someone asked if that you should kindly share how we can apply as a judge in the moot mediation. And the person added like a corollary saying that he or she had earlier participated in the same moot competition or moot mediation as a judge.
We shall be having a moot competition between USIU, University, Africa, and Women in ADR in honor of Lady Joyce Alwatch, who is our patron as Women in ADR. And in this moot court, for those who are not here, who came in a bit late, it is really equipping and capacity building the students so that they're better placed to handle mediations even out of school, out of college, more of an awareness and a practical approach towards it. So if anybody is an accredited mediator, wherever they are, and they would like to be judges, then we'd encourage them to apply to us through just the email for now, womeninadr@gmail.com. The moot court will run for a week. And as I've said, we are having universities from across the world to be a very good experience for the students. And it will also be a very good experience for the judges. And we'll also build your CVs, just giving back to the community. Thank you.
All right, thank you so much, Mrs. Wangwe, for your contribution and then your responses to the questions. It has actually been lovely having you on this session, on this webinar. So let's take Mr. Fajano, then I'll hand over to our host for today, Ms. Simi. Mr. Fajano, please.
All right, thank you very much. So for me, something that has come, a major, concern that I've been able to identify in my practice is sometimes the attitude of lawyers and legal practitioners. Sometimes lawyers are the parties or are the ones who influence their clients or parties to a mediation proceeding to withdraw cooperation. And sometimes you still see this adversarial mindset or attitude, which often derails the intention of the parties, and then of course leads to a waste of time, particularly in cases where there is a failure in mediation. So it's a big deal. I think a lot more lawyers need to show professionalism, get trained, and then of course perhaps ensure that they support the mediators, and their clients to ensure that the issues and the concerns are addressed and resolved. One of the things I also noted is the fact that there are instances where you see a lot of information come out in the process of mediation, and sometimes you want to ensure that perhaps if parties had to go back to court, in case of failure of mediation, you want to ensure that those information, evidences, documents, remain admissible, because there is a provision of the Act which speaks to conditions or instances in which some evidence which comes out, in the process of mediation becomes either inadmissible or admissible subject to some conditions. Sometimes it derails, and these are some of the reasons why some lawyers withdraw cooperation in the process of mediation, hoping that when they get back to court, they would be able to use some vital information that could have, helped in the resolution of the dispute in discourse. So these are some of the concerns: attitude of lawyers, capacity, and then access to structures and mediation organizations that can help parties to resolve their dispute better, faster, in a more professional matter, and then ensure that the essence of the court reference is achieved. Yeah.
All right, thank you so much, Mr. Fajano. For me, I would say that the key takeaway personally from the responses given by yourself and Mrs. Wangwe as mediators and lawyers, as well as Mrs. Achere Cole and Honorable Justice Kendago, from the institutional point of view, is training, whichever type of training we want to look at it, albeit advocacy parties, advocacy for disputants, for lawyers, training judges, training disputants too, because I know the LMDC does that. For parties prior to mediation. I think it's all about being knowledgeable, equipping stakeholders generally prior to going into a mediation session. Thank you so much, everyone, for attending this session, the webinar, and I'll hand over to our host for today. Thank you.
Thank you very much, Victoria. I would like to especially thank all our speakers. Thank you for the insightful presentations and contributions. Thank you for your time. To all our participants that have stayed till now, we truly appreciate you. Please follow us on our social media platforms, and we'll also be sharing the recording of this session via email. And briefly, we'll just announce our next topic, and we'll be meeting next in September, and we'll be discussing ADR revolution, how AI is transforming ADR, facts, fallacies, and the future. We'll announce our speakers on our LinkedIn page subsequently. Thank you, everyone, for joining in today. Thank you to our media collaborators, to the Lagos Multi-Door Courthouse, Women in ADR, American Institute of Mediators. I'm very grateful. Thank you for attending episode 1 of the Neutrals Nook. It's bye for now.
Thank you. Bye, Simi. Bye, everyone.
Thank you.
Bye. Thank you for having us. Thank you.
Thank you very much, ma'am.